People versus Shavers. Ms. Cassidy.
May it please the court, my name is Colleen Cassidy and I represent appellant Walter Shavers. The first issue I would like to address is the complete failure on the part of the police detective in this case to ask the simple question required by the clear guidelines established by this court to protect a suspect's right to counsel.
You say that the police have a greater right to inquire than perhaps we've been imposing in the past, don't you? I've got a problem.
No, Your Honor, I submit that this case falls within the cases decided by this court in the past, and that this court has always held that where the police know or have reason to know that there's a prior pending case against a suspect in custody, they must ask a specific question, which is...
But here the defendant said he had no counsel. What obliged him to go further?
Because he wasn't asked the question whether he had counsel in his prior case. The question...
Are they required to specifically, to put the question specifically about counsel in a particular case?
Yes, they are, because the...
What case requires that?
Well, every case from Bartolomeo, Bertolo, Lucarano, all the cases in this line of cases decided by this court hold that where there is knowledge of a prior case, there must be a question, do you have counsel on that case?
Is that what that precise question has to be asked? It's not good enough to ascertain whether or not the person has an attorney.
No, because the point of that question is for the police to inform themselves, to find out, once they know of this prior case, whether there's counsel on that case. In order to determine whether the defendant is represented by counsel, and they must cease questioning. What happened in this case...
What purpose would it serve to have them know exactly what case he had counsel on? As long as he said, no, I don't have counsel, why is it necessary that they identify the particular case?
Because if the question isn't specific, then it can't be answered specifically. And what happened in this case was the question, do you have an attorney, was asked as part of the Miranda warnings, at the end of the Miranda warnings. And it was simply another warning about this case, about the defendant's right to counsel in this case, whether he wished to waive counsel in this case. And it was clear from the context that what the question aimed at was whether the defendant had obtained counsel or had consulted counsel in this case. And the whole purpose of the Bartolomeo line of cases is to require the police to inform themselves whether the defendant has counsel on another case of which they are aware.
Do you read Bertolo as requiring this specific inquiry?
Yes, because if the inquiry is not specific, then the police have no way of informing themselves whether the defendant has, in fact, counsel in another case.
Ms. Cassidy, would you make that a per se rule, or are you suggesting that we have to inquire as to whether the police are engaged in some sharp practice by asking the question somewhat ambiguously, as you would at least pose it?
I am arguing that in order to find out the specific information that the police are required to find out under this line of cases, they must ask the question which is going to elicit that specific information as a per se rule. However, in addition, in this case, it's not that the question was ambiguous in that it could be interpreted to mean, do you have counsel on this prior case?
You say it's too general. It does not get down to the particulars of the given case.
Well, what I'm saying is that...
Doesn't the general embrace the lesser by saying, do you have a lawyer? And he says, no.
No, because it's not that it's too general. It's that the detective specifically testified that he did not ask about counsel in the prior case. He did not intend this question to have anything to do with the prior case.
Oh, so now you're asking us to look at the intention of the police officer with respect to this interrogation.
No, we don't even have to look at the intention because we have his clear statement, and we have a fact finding that he did not ask the question. He did not ask the question whether the defendant had counsel in the prior case. He specifically testified as such. What he did ask was another question. And
what was that question?
The question was, do you have an attorney as part of the Miranda warnings?
Do you have an attorney? And he says no. That
Yes.
does not embrace the lesser of the more specific inquiry that you're asking us to impose as a rule?
No, it does not, because what he was required to do was to ask whether he had counsel in the prior case once he knew about it. And since he didn't ask that, and he didn't mean this question to apply to that, and all he did was ask, do you have an attorney as part of the Miranda warnings, he could not reasonably rely on the defendant's negative answer
Ms. Cassidy,
as referring to that prior case.
Isn't the question rather whether the defendant could rely on the warning rather than the other way around, in terms of having a sufficient awareness of what protections he was entitled to, having been informed of the Miranda and saying, no, I don't have counsel?
Actually, the real issue should be what the detective was reasonable in assuming that negative answer meant. Because under Lucarano, even where the police ask a specific question, they know about the prior case and they ask, do you have counsel in that prior case? And the defendant specifically answers, no, I do not have counsel in that prior case. This court has held that the police are not required to go further if that answer is reasonable. If, under all the circumstances, they can reasonably rely on that answer as the truth. And
Ms. Cassidy, that would be sufficient, we have held, if you read it in connection with all our other cases, unless the police knew as a fact that this defendant was represented by someone else in connection with a pending litigation or a pending prosecution. Here, there was an affirmed finding to the effect that the police had no such knowledge. You're simply saying that by virtue of the fact that there were 2 recent crimes committed, or they knew of that they were given the affirmative burden of inquiring, and that this inquiry did not go far enough.
That's correct. And I submit that in the Lucarano case, this court held that even if there's a specific denial of counsel on a specific referred to prior case, the officer can rely on that and not make any further inquiry only if it's reasonable to believe that. And clearly in a case where the officer did not even intend the question to refer to the prior case, where he clearly stated on the record that he did not ask about the prior case, he was not reasonably justified in assuming that the negative response had any reference or any relationship to the prior case and whether the defendant had counsel in that prior case. And in fact, the defendant did have counsel.
Given the age of the prior charge, that certainly would have been a reasonable conclusion, would it not, that the defendant's answer was accurate?
No, given the age of the charge and the fact that he knew it had been a felony arrest,
It was more
he
than
should.
6 months old, though, was it not?
But a felony arrest is very likely to last more than 6 months, and this court pointed out in Bertolo that reasonable guidelines are the speedy trial guidelines, and for a felony, the prosecution is given 6 months in which to bring the case to trial, and there are many, many delays which are excluded from that, and as this court noted, it would be more than the 6 months, which would be reasonable for the case to still be pending.
Isn't it true that the detective did more than just give the Miranda warnings? In Miranda warnings, he just has to say you're entitled to a lawyer. He asked, do you have one?
Yes, but that was as part of the Miranda warnings. That didn't have anything to do with his obligations under Bartolomeo.
That can't be part of the Miranda warnings, is it? That's not.
It's not part of the Miranda warnings. However, that is the reason that he gave for asking that question.
But he did go, my point is, I'm trying to be sure we're seeing this from the record in the same way. The detective did go beyond the Miranda warnings in inquiring.
He did. He added another question, although it was not required. Perhaps he believed in the intervening days that the defendant had consulted counsel in this case, and that was why he asked it. But we don't know why he asked it.
Thank you very much, Ms. Feinberg.
Thank you.
Ms. Feinberg.
My name is Rona Feinberg. I represent the people in this case.
Ms. Feinberg, in Bartolomeo, we talked in terms of when the knowledge should be attributed to the prosecution or to the police. In Smith, even a short period of time, Bartolomeo, a longer period of time, or vice versa. Why shouldn't there have been knowledge here? These are 2 recent felony charges.
Well, in the first case in Smith, the police officer said that he assumed that the defendant was represented by counsel, but failed to ask the question anyway.
Why shouldn't he assume that here?
Well, first of all, when the charge was 6.5 months old, and it was the kind of charge that a great deal of time does get reduced to a misdemeanor, which in fact in this case it did, although he didn't know it at the time. Also, he had, when the defendant took the polygraph test, he told the detective that was giving him the polygraph test, she said to him, do you have any past problems with the law? And all he referred to was a 1971 case he had. Now, it's true he didn't say this to Detective Johnson, But the polygraph Detective Silva and Detective Jonza obviously were discussing the case, because when she came out to talk to Detective Jonza and tell him about problems defendant was having with the questions, this was one of the questions that she was referring to. And although it's not clearly on the record that she told this to Detective Jonza, I think that it's reasonable to infer that this discussion did take place.
Are you suggesting that the defendant's statement that he didn't have a lawyer would not be sufficient to avoid the Bartolomeo rule if the pending charge was recent enough?
No, my position is that in any case, no matter what the detective believed, the fact is that he asked a question. He asked the defendant if he had a lawyer, and in fact, he gave the defendant more latitude to be protected because this question could encompass anything. If the defendant had a lawyer on a landlord-tenant case, he could have said, yes, I have a lawyer.
The answer standing by itself is sufficient.
That's our
That's your
position, yes.
position. Yeah.
Well, of course, the defendant could have assumed he was talking about a lawyer in connection with that particular case, the case which was the subject of the inquiry.
I think that's an...
Why wouldn't he have said, are you represented by a lawyer and the other case is pending before the court?
Why wouldn't the detective have asked
Yeah,
that?
that would have been such an easy question to ask, and then we'd have no problem.
Well, I think that puts an undue... First of all, he didn't believe the case was pending, and he asked the question anyway. I think that would put an undue burden on the police officers, because then where would we draw the line? Would we say, well, if you have a defendant's rap sheet in front of you, do you have to go down the whole sheet and say, were you represented on this, were you represented on this, and go down for each case?
Assume that the police officer knew that these cases were very much alive and very much pending. Would his inquiry be sanitized by simply asking this one question, do you have a lawyer?
I believe that it would.
I'm going to drive you one step further then. Would you suggest to us that the answer insulates the situation where the detective or the police officer actually knows that there is counsel in a particular case, asks the question, no? Are you saying that the rule is that there's no violation there?
Well, I think in that case, then maybe on the good faith, maybe we'd have to consider the good faith of the police officer, and in that case, maybe he was being evasive.
You can't take the defendant at his word.
Well, I believe that you can take the defendant at his word, but if we're going to start saying that one isn't giving him enough and maybe the other is giving him too much, then maybe we have to look at other factors. And in a case where the police officer knows that he has counsel, even if the defendant denies it, I'm not sure that the police officer would be acting in good faith by going by defendant's word.
Are you suggesting that, did I hear you correctly, that if the police officer even had the defendant's rap sheet in front of him and saw that there were items on that sheet, recent arrests, the case is open, that he'd have an obligation to inquire?
Specifically about each case? No, I don't believe that
What
he
about
would.
the most recent case? What about a case of 6 months outstanding?
Well, I
It does
think
not
that-
show a disposition on the rap sheet.
No, I think that he would have to inquire whether the defendant had an attorney. But I think if he asks whether, do you have an attorney, that it sufficiently encompasses all of the cases, that it doesn't have to be more specific. I think that places an undue burden on the police officer. And I also think that if a police officer only has the duty to say, do you have a lawyer, that the question might get asked more often and defendants might be better protected by it than if the police officers had to remember to enumerate each case. I think that this gives defendant more protection rather than less.
Haven't we also imposed a requirement that the defendant's response be reasonable? And was that requirement met here?
Yes, I think it was reasonable because I think Detective Johnson seemed to be very sincere on the record in his testimony, saying that he thought that the case was over, but that he genuinely believed that this was a question that had to be asked, that was supposed to be asked to defendants. I think he even said that he thought that it was going to be added to the Miranda warning sheet, and he asked the question because he saw that it wasn't there, and he in fact wrote it down by hand. So I think that it was reasonable for a 6.5-month-old case like this that does routinely get reduced for Detective Johnson to believe that it was finished. And in fact, he went out of his way to ask the question anyway, which he didn't have to, according to his belief, he probably didn't even have to do. And I don't think there was any question that he wasn't trying to get away with anything or put one over on the defendant.
Thank you very much, Ms. Feinberg. Capital Newspapers versus Whalen.
Ready to report, please.
Mr. Danziger, what if these were very personal kinds of papers here?
Well, at the outset, I believe it's important for the court to note that Mayor Corning did have files with private letters and other private materials that were turned over to the Corning family and are not part of petitioner's request. If the mayor had other personal items that he then systematically filed and interspersed along with all the documents of the records of the office of mayor, and they are kept and filed and maintained along with all the hundreds of thousands of records of the office of mayor, then they are, under the New York State statutory definition, records of an agency and would be subject to FOIL.
Those relating to his personal activities could be culled out, could they not?
Absolutely, and then it would be subject to the exceptions in FOIL. It may be an unwarranted invasion of personal privacy. We recognize that throughout this. Our major question here really is a question of the procedure. Is the court going to let the appellate division decision stand, which would allow agency employees to cull through the admittedly interspersed, intermingled thousands of documents and make their determination without benefit of any guidelines, without any of the FOIL procedures, without administrative review, without court review, and make their determination, a determination that Mayor Corning didn't make during his life, and be permitted to make a determination that these are personal or political documents that don't come within the purview at all of FOIL, and therefore they would not even have to begin making the arguments for exception.
If a document can be isolated and is a personal document, you concede that it's not under FOIL.
Well, no, it would be under FOIL procedurally, but then it very well may be an exemption.
What brings it under FOIL? The mere fact that it is filed in the office of an agency?
Well, it's more than just the physical location. If a personal letter comes in to the mayor, at that moment that it crosses the threshold of the door, I don't believe that makes it a record filed or maintained with the agency. But at the point where the mayor makes a determination not to put it in his private file or not to take it home with him because it was a personal letter to him, and he files it along with his other thousands of records of the office of mayor in his elaborate filing system and makes the decision to integrate it in the agency's files, at that point it's an agency record, and then he would have to establish the exception.
It would be treated, you say, or should be, as a public document, a FOIL document, but subject to the
All the exception. Absolutely, Your Honor.
exemption requirement.
Absolutely.
Mr. Danziger, you refer to interspersed and intermingled and integrated in your example. Is that what's key here? If the keeper of the document were to establish a separate file, would that be the key consideration, or does it have to be mixed in with other records of the agency?
Well, I think that is a key consideration. Assuming it is...
But if they are kept separately, then they are not subject to FOIL.
Well,
Although kept in the office of the mayor.
assuming again that it's not produced by, with, or for the agency. Some things may come in that were produced for the agency, and those would remain, those would be agency documents no matter where the mayor put them. But assuming it's a purely personal letter, and he puts it in a private file and maintains possession, control, doesn't use city employees to store it and file it and reproduce it, etc., and he makes that determination, which are not the facts in this record, because those private files were already turned over to the Corning family. The hypotheticals in the city's brief about his tax returns, his Visa account, his bank statement, those are merely hypotheticals. The personal things were already transferred to the Corning family. What we have are letters and documents that the city employees, not the mayor, the city employees are now claiming are personal.
Ms. Stanzer, going back to Judge Kaye's question, now, are you saying that everything in the office now should be subject to some kind of review, be it in camera or otherwise, to determine whether or not they would be subject to FOIL?
Everything that now remains in the office, all the records, are clearly records of the agency and therefore come under the procedures of FOIL. Only the small portion of documents that would be disputed in terms of being an exemption.
What if you went in the agency right now and there's one big fat envelope and it had on there, private papers of Mayor Corning, not to be disturbed? Is that to be looked at?
At this point in time, where it's no longer in his possession, it's now really transferred into the city's possession. It's in the city's Hall of Records. It's been refiled and re-indexed by city employees. It does come under FOIL, and there have to be procedures to determine whether it's proper to, that it is an exemption or that it's not, and that should be subject to administrative review and in-camera review if appropriate.
Mr. Danziger, earlier you alluded to the fact that you were unhappy or dissatisfied under the rule with someone from the city, the information officer, the committee under FOIL, whatever, making those discernments. Is it preferable to have the judicial branch and judicial offices in that part of the business, or isn't it better to have that done initially there?
Well, initially it should be done there, but then if it's contested, then there should be a mechanism for administrative review and court review if the court deems it appropriate. But under the appellate division decision as it now stands, they're saying that all of these potentially thousands of allegedly personal records that have been interspersed and are mixed in with this elaborate filing system with hundreds of thousands of documents are just not records under FOIL at all. And that whenever there's a request like this, the agency employees can just go in and essentially purge the files. And in future cases, that's the biggest danger, that you're basically going to have the foxes guarding the hen house. Once there's a request that's been made, they can go back in and they have something that's broader than an exception. It's just not part of FOIL. They can go in and they can pick out, well, this is signed your friend the mayor, so this is personal.
Well, contrary to what you said earlier, then you would seem to be making the test based solely on location. If it happens to be there, it's all subject at least ultimately to
Well,
review.
It's location plus here the systematic filing and integration, and now it's the maintaining and filing. They're kept and held by the agency.
But in response to my question, you said even if they were in a separate envelope marked as Mayor Corning's personal property, the fact that it's located there would subject it to review.
Well, that's where the fine line is drawn. That's the very difficult question. The way I've separated out in my mind is that the record, where he did that during his lifetime, before these records were transferred over to the agency, if he had his own private file labeled Private Personal Mayor Corning, and he takes that with him, he gets a personal letter, he takes it home, I don't believe that that...
Why don't you say, Mr. Danziger, that anything in the public office is subject to FOIL? That if it's in the property of the government in this public office, and it's in the files of the... It's in the public domain.
Well, if it's in the file, I think now you're going to get into a question of is it in the file or isn't it in the file. The records that sit now are in the file. He may have had his checkbook lying in his desk drawer that was given over to his family, and that's not...
What if the checkbook was still in the desk drawer?
At this point in time, it's being held by the agency. That makes it a record under FOIL, and then it would be exempted as an unwarranted invasion of personal...
But what if it was still in the desk drawer? Mayor Whalen just never got around to cleaning out that desk drawer. There it sits.
And we make a request
Yep.
today for that.
Yep.
He has it's not filed, kept, and maintained by the office of the mayor, his personal checkbook. I think it becomes a factual question. If he's put it into the file, if he has people file it in the file system with all city checkbooks, well, he's chosen to make it a file of the office of mayor.
Desk drawer, you don't get it. File, you get it.
Well, the statute says kept, held, or filed. That's...
So you say maybe you do get it because it was kept there too long. If they'd gotten it out earlier, then you wouldn't get it.
Perhaps. It's a difficult line to draw.
Sure, you don't have to worry about that. We do.
Well, that's not the line that has to be drawn in this case. The problem we have is that the appellate division has gone all the other way to say, even though the checkbook has already gone out and is with the family and they took the private file, the thousands of documents that interspersed The appellate division is saying, go ahead, city attorneys, just take those out, those
All
aren't
the
records.
All the records you want are interspersed in city files with clearly city business.
Absolutely.
Is that correct? There's no file cabinet over in the corner of his office that says personal stuff over
That was
there.
already given to the Corning family, and that's not an issue.
Everything you want has been filed by city employees and mixed in with city files.
And
Absolutely.
therefore, you really believe that the city workers or the agency workers shouldn't be the ones to determine which are personal and which aren't? And that should be done by some other party other than
Well,
the
no,
agency itself.
if it's under FOIL, the records access officer in the first instance makes a determination. Then if we want to appeal it, then there's an administrative procedure, and ultimately it may go to the courts. The difficult question is, those that aren't integrated, it's really not part of this case. I don't think the court has to deal with
Is
it.
that true as to the alleged party records as well as the personal records?
Yes, now that they've
They're
become,
totally interspersed with the...
absolutely. It's admitted, it's an admission in the record by corporations, city's attorney.
But that then makes what would otherwise be private records, public records. They're kept in a public place and they're interspersed.
Filed and integrated, interspersed, yes.
And that brings them under the exception provision. You have to go that route, you say.
Absolutely.
Is there any other mechanism short of going the exception route which would accomplish what should be accomplished here, namely the weeding out of the private?
Well, I think the easy solution is really, I think, what Mayor Corning did. During his lifetime, during his tenure, he kept his private file private. And he made a decision, and he labeled his things private, and he kept it private, and that went to his family. The records that he chose to integrate into this elaborate filing system became part of the records of the office of mayor. And I don't think it can be left to the agency employees to go back in and purge the records without administrative or court review.
I'm not suggesting that should be, but the result of your rule is to make something that's private, public, subject to FOIL, and
Well,
you make the person
that-
go the exception route. Is there any other way to accomplish what should be
Well,
accomplished
that's
here?
really the initial decision of the office holder to decide whether they take what comes in that might initially be their personal record and place it in the agency file. If they don't, there's nothing to require them to take their personal document, a personal letter, their tax return, and place it integrated in an agency file. Although here, again, I say those are hypotheticals. I don't believe that those are the records that are left, and I don't think that's what...
And do we know for absolute sure that it was Mayor Corning who integrated these records rather than someone thereafter? And wouldn't that be...
It's admitted by the city that he filed both his personal and executive papers at City Hall. They describe this elaborate filing system, the separate topics by year alphabetically, et cetera. So those facts are really admitted. It's a question of what the law will be on that.
Thank you very much, Mr. Stansky.
Thank you very much.
Mr. Dugan?
May it please the court,
Didn't Mayor Corning really decide which papers were going to be subject to FOIL and which ones weren't?
he did. As a matter of fact, he went through his papers a couple years before his death and consolidated these personal type
The
of...
ones that he left integrated with the city files, he apparently, not that he consciously thought of FOIL, but that was the consequence of his decision, wasn't it?
I don't think so, Judge. First of all, I don't think he had time to get to all of them. But this elaborate filing system that's described isn't really so elaborate. It's basically an alphabetical order under several categories. I'm sorry now that I ever used the word interspersed in my brief. And if you look in the record, it's fairly easy to pick out what's a personal file. There's a file like for Yale in there, and there's a file for, it says politics, and one for county chairman. You can look at that index and look at it and say, those are probably personal
Why shouldn't
files.
these be subject to FOIL? Under FOIL, you don't have to show a basis.
Because, Judge, the entire preamble to this statute talks about records of government. There has to be some connection between what the city does.
What if there's a legitimate inquiry being made by the press to show the use of the agency and the agency facilities for partisan political purposes? And the best proof of that is to show the very records kept within the agency of the partisan political activities.
But your question is circular because you're saying it's a record automatically. If it's some letter from Mayor Corning, chairman of the political party, to some contributor of the political party, there you have a problem.
That's not a record.
No, it's not a record.
Don't we have to look to the definition of record in the statute? And under the statute, wouldn't that be a
Well,
record?
you can, Judge, but it's not much help because there's so many conjunctives and disjunctives that
How does the
there's a
statute
peg
define-
for everything to hang on.
You're trying to say that under the statute, that would not be defined as a record?
Not the way the appellate division has interpreted it, because Chairman Corning is not an agency. And you have to be an agency to generate a record. So the answer is no, it's not a record.
How would you say the problem should be handled? I gather you disagree with the rule that's proposed, that what would otherwise be a private document filed in a public office and interspersed with public records becomes a public record subject to FOIL. You don't agree with that?
No, I don't, and the
Now, however, they're in the file where the private and public records are interspersed. There are some public records which should be subject to FOIL. If you don't use the exception route, because these private documents don't become public documents, and therefore it's subject to FOIL, how do you weed them out?
I think there's
How do you do it?
There's an initial level of inquiry that can be made, and I think that the requester should have a higher level of responsibility in describing it. For example, if he says, let's see all of Mayor Corning's letters from the Yale Alumni Association, you can look at that and say, well, wait, what's that got to do with the city government? Then they should say, well, wait, it has to do with this because Mayor Corning used city funds for some Yale function.
I thought
Then
the
they
burden
could look
went
at
the
it.
other way. Once they're in your possession, it's up to you to show that they're exempt.
If it's a record, and if it's generated by an agency. But the appellate division has already described it as Erastus Corning citizen is not an agency.
The exemption burden only comes if they're public documents.
Exactly.
All
If you
right.
start having to apply the
But,
exemption
all
burden,
right, now, if you-
everything's
If you
included.
don't say a private document is transmuted into a public document by virtue of its filing and interspersal, then the selection process that you're talking about is done by whom? Who does it?
Well, in this case, it could only be done by a representative of the city because they're contained in city file cabinets. But initially...
Can there be any supervision of that by a representative of the court or anything of this kind?
I think upon some further showing by the requester that the city has made some improper decision, there has to be something more than just a base request for a document which, when named, can be looked at and said, yeah, that's probably has something to do with city government.
But basically, it's a unilateral decision.
Initially, it would have to be. If the court got in the business of reviewing 328 cartons, it would take one judge approximately a year to do this.
Yeah, that's a problem.
Mr. Dugan, I'm having difficulty following your definition of a record, and particularly against the definition contained in the statute. The documents are presently being held by an agency, isn't that so?
That's correct.
Doesn't that then make them records within the meaning of the FOIL statute?
No, it doesn't, Judge, because if you take a common sense look at the statute,
How about if you stay with the language of the statute?
but you can't, if you stay with that language and take that reading that only location matters, you reach a nonsensical result. Just because a document happened to be received at City Hall, it's automatically a public
Not only
document.
received, but held to this very day in the agency file.
But it's, judges, I mean, it's not, because it's kept a longer period of time doesn't change its character.
No, because if it were a personal record or someone else's record that had found its way to City Hall, presumably the person whose personal document it was would have taken it somewhere else. But once the record remains, or is held, or is filed, or kept, or maintained in the agency file, why doesn't that, under the language of the statute, become a record subject to production?
Well, Judge, I have to disagree that they would take it somewhere else. I think, as Judge Levine noted, it's customary and expected for a person to keep personal records in their own office, especially Mayor Corning, who'd been there for 40 years. But if you read the statute in a commonsensical way, you have to say that it has to have something to do with the business of the city of Albany that they transact.
Well, are you saying that the initiation of the record has to be something that deals with the business of the city? Is it not enough here that the city has taken possession of these records, in a sense, made them city records by cataloging them, filing them, and keeping them in city property? Would that be enough to make them subject to FOIL?
I don't think so, Judge, because Erastus Corning did that initially. Only because he died, someone has to physically take these and sort them out. The records of his correspondence as chairman are property of the Democratic Committee. His private papers should go to their estate. No one's had time yet to go through all these documents.
In addition to Judge Alexander's point, though, point of inquiry, picking up on your assertion, we don't know, nor does the public, those making the request, whether these documents have any relationship to city business. Isn't that the whole point of the request?
Exactly. No one would know unless you actually read the document. Someone has to read it, though, initially.
But doesn't that argue for availability? Because the potential for integration and involvement with public business, the city business, is such that it may fall within not only the statute generally and its purposes, but the strict definition of record.
Only if you create some presumption that the city agents are going to disregard the law. And you can't create that presumption. You have to put a higher burden on the requester if personal papers, nominally personal papers, have something to do with the business of the city. They should raise that issue.
We don't have to presume that they're going to violate the law. We just have to accept the fact that they may not be in the best position to know. That someone else, more objective, may be in a better position to make that determination as to whether there's no way to separate out the public and private life of some individuals in the exercise of a public function.
I think, Judge, if you argue that, then you've put the judiciary in the business of initially reviewing all the papers. I think you have to make the requester come forth with something more than just, this is a public document, let me see it.
Unless we should adopt a rule that if a document is filed in a public agency and interspersed and filed with other public documents, then it's presumptively a public document, and that casts it into the exception route.
You could adopt that rule, Judge, but I think you'd be rewriting the statute.
That would be bad, wouldn't it?
The legislature would probably.
We would never admit to such a thing even if we did it. Thank you very much, Mr. Dugan. Matter of Johnson versus Morenthau.
Ready for court, please.
Mr. Neufeld, suppose the defendant had the gun for 10 years. Only one conviction for the possession of that weapon?
Yes.
So he has the other 9 years on a buy.
Well, if the prosecution occurs at the end of the 10 years, in the Jones case, for instance, it occurred at the end of the 3 years, we have one prosecution for one continuing course of conduct. The state gets one bite at the apple. If you have a continuing course of conduct and you have a prosecution somehow in the middle of that, then I think case law is quite clear that you have a situation similar to an assault followed by a prosecution, followed by the death of a victim, where of course then you can prosecute for the murder after the initial prosecution, because in that case, the state doesn't have all the evidence, they don't have all the possible charges to put together in that one case. Here, that's not the situation. Here, you have 6 days, you have one continuing course of conduct, one gun possession.
What if he loaned the gun to somebody for whatever reason, for a month or so, breaks the chain of possession and connection, and somehow or other it comes back to him? Still same answer, that the state's only got one shot at him, so to speak?
The question is whether or not the person maintained possession for that period of time, either constructively or otherwise. If the state can show that you have two separate possessions, as the Third Department noted recently, where they meet that burden, where they say, here somebody got rid of the gun and intended to abandon it, and if that can be shown, then you do have two possessions, and then you can have two prosecutions. But where that can't be shown, there's a presumption in this state of continuance, and common sense tells us that somebody who possesses something like a gun, unless it can be shown that they abandoned it, probably did maintain it.
Where does the presumption of continued possession over any long period of time of a weapon come from?
It's just a general presumption in the law of continuance, that something that occurred at one point, presumably, unless it can be shown otherwise, it's a rebuttable presumption, occurred at another point, continued to occur, things that are likely to occur. And we're talking here about the possession of a gun. In the Brown case that we're talking about,
Isn't it
the possession of a car.
isn't it just as reasonable in human experience and the law to presume that someone in possession of illegal materials or contraband would not continue to possess that and would get rid of it as soon as possible? Isn't that a reasonable presumption to impose under the law?
Not when you've seen that they have possessed it, in fact, at 2 points in that continuum. That is, in Brown, the man stole the car on one day, and 9 days later he's arrested possessing that car. Is it possible that he lent the car out or sold it and then bought it back? It's possible. But I think the cases are quite clear that the burden on showing that has to be on the people. Otherwise, what you have is an impossible situation. You have the situation where a defendant, in this case, over a period of 6 days, in Brown, 9 days, in Jones, 3 years, would have to prove that every second he possessed that gun. Here,
How do the people prove the contrary? Sounds very difficult. Prove non-continuous possession.
well, the
That's
Third
almost
Department found that
impossible, isn't it?
the Third Department just found that it was proved in a gun case recently, where they showed that the person had in fact gotten rid of the gun, abandoned it intentionally, and then gone back the next day and gotten it. If you have the evidence to show that two crimes, as in any other situation, if you have evidence that two crimes have been committed, then you can have two prosecutions. If you only have evidence of one crime, you only have one prosecution.
Suppose the second possession were incident to something else, like an assault or a robbery or something. But there's no way of proving that there was any interruption from possession 1 to possession 2. Does the fact that there's an additional element to the second incident, does that do anything, or is it the same rule that you adopt?
Well, then what you would have two prosecutions. For instance, if a fellow has a gun and he shoots somebody with it on Tuesday, and then he robs somebody with that same gun on Wednesday, you've got two prosecutions there.
Right,
but
but
those go to
talking
the
only-
use of the gun, not the possession of the gun. The possession of the gun, in this case CPW 3, can only be charged once. I think the basic reason for this rule is that if we hold otherwise, if this court were to hold otherwise, then we would allow the prosecution to determine the unit of prosecution. It would be up to in this case, the district attorney to decide whether 2 days is reasonable, or 1 day, or a minute. And that's exactly what the double jeopardy protection was designed to prevent. That's why when the legislature explicitly says the unit of prosecution is a day, as they did in the Environmental Conservation Act, that every day you pollute, you've created a new crime, that's fine. Person's on notice, there's no arbitrary question, the courts are clear on it, the polluter is clear on it. But where the courts haven't done that explicitly, where the legislature hasn't explicitly done that, then, as the Supreme Court said in Bell, the rule has to be that the unit of prosecution is one, and you're only allowed the one prosecution.
It makes no difference that you've crossed a jurisdictional border, different counties?
That's correct.
That's no break in the nexus either, according to your argument?
That's correct. I think we frequently have crimes committed in this state in more than one county, and they're prosecuted in one county. And the state has to decide where are we going to prosecute this case. It happens all the time.
Whoever gets there first, as between the prosecutors? Do we have contests then between prosecutors as to which, because it's not a single prosecutor in the way that you were describing, making that decision then?
Well, we frequently have cases where prosecutors have to consult among themselves and decide who is going to prosecute a crime that happened in more than one place. in the new state RICO law, we actually have a procedure for the district attorneys to decide among themselves who's going to get the prosecution and how to divide up the proceeds afterwards. But that's for the state to decide. That's the state's problem, and it's the district attorney's problems as part of the state to resolve that question. Once they decide which county to prosecute a crime in that took place in more than one county, they can prosecute it in that county. They just can't prosecute it in the second county, no matter what happened in the first county.
What was the length of time in Brown?
9 days.
Now, in your continuous possession theory, is there any outside for time, or
No, I don't think time is the question.
not a question?
I would also point out that the district attorney's argument here and the argument about the amount of time counties is exactly the same argument that the dissent raised in Brown, which was rejected by the Brown court. And it's not the law in this country, it's not the law in this state. Would only add that the continuing course of conduct in this case also comes within the statutory double jeopardy ban of CPL 4022, same transaction test. I think I went into that sufficiently in my brief, and I won't burden the court with it here. Thank you.
Thank you very much. Mr. Neufeld, Ms. Morse.
Thank you, Your Honor. May it please the court, my name is Deborah Morse, and I represent the people on this appeal. If the court would permit me a few moments at the outset, I think I'd like to frame our argument in a somewhat different perspective that might clarify our position for the court. Essentially, petitioner's claim is that under Brown, the two offenses are so closely related that they constitute one offense, which may be prosecuted only once unless the legislature explicitly so provides that they may be prosecuted more. And I would say that in this case, although in our brief we dispute somewhat that interpretation of Brown, assuming for the purposes of argument that that's true, in New York, our legislature has specifically so provided, and it has done so in Article 40 of the CPL. It said that under certain circumstances where two events appear to be so closely related that it appears that they may not properly be prosecuted twice, one must subject them to the single transaction test. And if the facts of this case are subject to the single transaction test, it's clear that this appears to be only two separate transactions. And in a sense, that responds to, I think, Justice Walker's question about whether a defendant may be prosecuted more than once if, in fact, his possession is 10 years later. Under certain circumstances, he could be prosecuted twice, and under certain circumstances, perhaps he couldn't be. It would depend on the nature of his possession on the first date and on the second date 10 years later, and would also depend on the circumstances of his possession in between, and more importantly, the purpose of his possession, perhaps during the entire time period, if in fact there were such a continuous possession. And I would ask the court to look at the words of...
Are you saying, therefore, that prohibition shouldn't lie and it should be left for a fact determination of some kind in the prosecution of the two matters?
I would certainly say that if the court were to resolve it at this point, there are sufficient facts in the sense that the petitioner has not alleged anything which would suggest that these are two separate criminal transactions, that these are one criminal transaction. If the court would prefer to wait and resolve it at a future time when there are more facts, the court would certainly be free to do that. But certainly at this point, the petitioner has the burden under an Article 78 proceeding, and if he's suggesting that he has shown that these two are one single criminal transaction, I would say that we would come to the opposite conclusion.
This is under statutory double jeopardy,
Yes.
40?
Yes.
But the petitioner here is relying on constitutional double jeopardy under Brown.
I would suggest, Your Honor,
You
that...
don't think so?
I think it's superficially, it's certainly couched in terms of a constitutional argument, but I think in Brown, what the Supreme Court was responding to was the Ohio legislature's silence on the question of how to respond to something which would seem on its face to be two offenses which in fact are perhaps one, that they're perhaps bridged by some logical connection.
Why don't we have to look at this and these two episodes under a constitutional test? Maybe the petitioner doesn't make it, but it's been asserted we have to examine it, don't we?
Well, I would suggest that under traditional constitutional analysis, these are clearly two separate offenses, but for the notion that it's some sort of continuing offense, which I would...
That's the argument.
But to the extent the petitioner relies on Brown for that argument, and perhaps also Jones, both of those cases said specifically that they were looking at the particular statute under which the defendant in that case was being prosecuted. And if we were to look at the statute in this, neither case articulated some sort of federal rule or a constitutional rule, if you will, that a possessory offense, a possession of contraband, must be deemed a continuing offense and one offense for constitutional purposes. I think, Your Honor, what they were saying is simply that they were not certain that the Ohio courts or that the Illinois court had specifically dealt with the possibility that perhaps they were one offense under Ohio and Illinois law.
I realize we have to do that, but my question has to do with whether we apply 40
Yeah.
constitutional double jeopardy or the constitutional double jeopardy rule.
Well, Your Honor, I certainly would suggest that we could meet, that this situation could meet the constitutional test, but I would also argue that it could meet the much broader and much stricter statutory test, which New York has provided, which has said New York has said essentially we want to provide more protection than the constitutional analysis provides. And we've gone even further, and we've said even if these can be viewed as two separate offenses, there are certain circumstances under which one may not be prosecuted properly twice for what appear to be two separate offenses, because under certain circumstances, for double jeopardy purposes, those are properly viewed as one criminal transaction.
Ms. Morris, are you saying that under either test, the federal constitution, double jeopardy, or under Article 40, that what we have here is the exercise of a non-reviewable discretion by the appellate division in denying the writ of prohibition?
I'm not sure if I understand.
Because there's more to be discerned in order to apply either test as to whether it is a separate transaction.
No,
Do they have the right, as a court, to exercise a non-reviewable discretion in the granting, or denying in this case, of an extraordinary writ like prohibition?
Well, to the extent that, if I understand your question correctly, to the extent that that means that the Article 78 proceeding must be decided on the basis of the facts that are alleged in the petition, I would say that the petitioner has not met his burden under that, and in that sense, perhaps it's not reviewable. But if this court were to go on and to review the merits of the underlying claim, I would suggest that the case meets the standards set forth in both the constitutional analysis and the statutory analysis. Such that
I'm trying to discern whether you're erecting a threshold procedural problem, because you're not saying that the appellate division lacked the power to entertain this and exercise it in the way they did in denying it. And we may be, depending upon your perspective, barred if there are factors underlying this, and we don't know, they didn't tell us, that prevent the review of the discretion that produces a denial of this writ.
I don't know of any powers that would prevent your review of the denial, Your Honor, other than perhaps which I imagine is unrelated to your question, the notion that this involves a constitutional question and therefore it's here as a matter of right. It seems to me that there's nothing that I know of that would prevent this court from reviewing the denial.
In either analysis or any analysis, you have to talk about the double jeopardy problem, do you
Yes.
not?
Yes. Thank you, Your Honor. I see the red light is on.
Thank you very much, Ms. Morris. Dynamics of America versus Marine Midland.
May it please the court, my name is Robert Gottlieb. I represent Dynamics Corporation. There are a few points I would like to make initially. Marine, the respondent, starts off its brief by stating that the central issue on this appeal concerns a violation by DCA of its duties as a debtor under Chapter 11. I think our brief makes clear that there has been no violation here, and as a result, there should be a reversal. A failure of a debtor to schedule a claim he has no reason to know of doesn't constitute the violation of a duty to anyone. Chapter 11 debtor is in no position different from a trustee who, for example, fails to pursue a claim he has no reason of.
Assuming, Mr. Gottlieb, that indeed there was no knowledge of this claim, what exactly should happen with it in light of the Chapter 11?
Your Honor, there's a whole series of cases, starting with this court's decision in Rand in 1906, and for that matter, Danziger in the Supreme Court of the United States, which makes it perfectly clear that Marine cannot argue here that the case should be dismissed, and if the creditors want to pursue the matter, they can do so themselves. Just for a moment, I can quote from Rand at page 61, where the court says, "It may very well be that any sum recovered by the plaintiff in the present action will be held by him as trustee for his creditors, but this is a matter which does not concern the defendant, bracket, Marine, so long as the plaintiff holds the legal title to the claim and the defendant is secured."
Well, that's exactly my question. Does the plaintiff hold the legal title?
Yes, Your Honor. The only cases that have, the only authority for taking away title to the claim would be Section 70A. Section 70A only applies when a trustee is appointed, and that was made, as far as we can tell, perfectly clear by the Supreme Court of the United States in 1928 in the Danziger case, which specifically says that the doctrine of Lassiter does not apply when a trustee is not appointed. This court so held also in 1906 in the Rand case, where if you read the decision, the court says it may be, and I quote the word, reprehensible, that there has been no listing. In our case, we believe there's nothing reprehensible about it, but unless title transferred, which it did not, we have always had title here. Also, Section 342 of the Bankruptcy Act, which Marine never really mentions in its brief, specifically says when no receiver or trustee is appointed, the debtor shall continue in possession of his property and shall have all the title.
Is it central to your contention that the debtor did not know of the existence of this claim? It's plain that if the debtor did know, that a different result would have...
Well, Your Honor, there are two lines of cases. Where a trustee has been appointed, we believe that if there's been an unintentional failure to schedule, the claim can still be pursued. Where no trustee has been appointed, Danziger and Rand say that you can pursue it even though you know. In our situation, no trustee has been appointed, and we did not know of the claims.
Such a construction would permit a debtor to conceal claims and thereby escape sharing an asset with creditors at a time when creditors will be compromising the amounts that are owed to them.
Your Honor,
That doesn't seem right, does it?
if the courts are more than able to determine whether or not a debtor has concealed a claim, in this situation, we believe from our perspective, it's clear that there has been no intentional
But if you say
concealment.
the claim remains the property of the debtor, it doesn't even require any kind of nefarious concealment. You would say it's simply within the
Well, as a matter of
choice
time,
of the debtor to keep a claim, either to put a claim in the chapter or to keep it out.
Your Honor, as a matter of law, the debtor would be obligated to disclose the claim in the schedule if he knew about it. If he didn't know about it, he can't be required to do what he can't do. But if, in fact, the creditors have a right to these sums, they can go into the bankruptcy court or go into some other court and seek to obtain the proceeds of any recovery. Now, why Marine should be able to make this argument where we claim they're the wrongdoer really basically makes no sense, and that's the clear teaching of the Danziger decision and the Rand decision. Insofar as title is concerned, we believe we always had title. But in any and all events, we didn't know about the claim. There's ample support in the record for a finding that we did not know about the claim, but certainly there's an issue of fact from at least Marine's perspective as to whether we knew about the claim. And as a matter of law, neither special term nor the appellate division could find that we knew about the claim. And we would say that at a minimum, there would have to be a hearing on whether or not we knew about the claim. We found nothing in the record to demonstrate in any respect that we knew about the claim. The only claim against Marine which we knew about are the so-called lockbox causes of action. Those causes of action were pursued during the bankruptcy proceedings. They were pursued with the full knowledge of the bankruptcy court and the creditors committee. And I think that itself indicates to the court that DCA was willing to litigate with Marine when it knew about causes of action against them. And in the 5 or 6 months after the bankruptcy had concluded, we found specific facts, and there was a holding which supported causes of action, and we asserted those causes of action. I've heard my adversary argue that this situation is no different than the corporate officer who, before bankruptcy or during bankruptcy, finds assets, puts them in the ground, and then thereafter seeks to use them